move to the next session of the day. May now request Mr. S. Srinivasa Raghavan, President of MMBA, to come over to the dais. May now request Dr. Sanjay Jain and the better half and the vision of Dr. Sanjay Jain, Mrs. Sakshi Jain, to be accompanied to the dais. May now request Mr. Kumar to honor the guest speaker with a memento. May now request Mr. Arumugam to adorn the guest speaker with a traditional shawl. May I also request Ms. Mahalakshmi to present a shawl to Mrs. Sakshi Jain. Now I take this moment to share a few words about the guest speaker of the session. Dr. Sanjay Jain has teaching experience of 25 years across various reputed institutions in India, and presently he is a professor of law in National Law School of India University, Bangalore. Dr. Jain is passionate about disability rights. In 2004, he received the National Award in the Employee category instituted by the Ministry of Social Justice and Empowerment from the former President of India, Dr. APJ Abdul Kalam. Dr. Jain have authored various books, articles, law reviews and journals. His works involves articles on disability rights, gender equality, aviation rights, information technology and intellectual property rights. Presently, his articles have been cited by Honorable Chief Justice of India, Dr. D.Y. Chandrachud, in the case of Vikas Kumar vs. Union of India, decided on 11/2/2021, which held that an individual suffering from dysgraphia or writer's cramp is entitled to a scribe in civil services examination.
The topic, role of intersectionality in anti-discriminatory laws. In the social system of caste, patriarchy, misogyny, sexism, racism, homophobia, hate towards difference, to stand as an inclusive society, to grow as an inclusive society, we need to uphold justice. To uphold justice, we have anti-discriminatory laws envisaged by our Constitution in Article 14, 15, Article 21 and so on. The principles of equality, liberty and fraternity given as a fundamental right. The principle of intersectionality aids to ensure anti-discriminatory laws. It builds further on the words of the great philosopher Aristotle. Equals should not be treated unequally and unequals unequally. The principle of intersectionality acknowledges the experiences of discrimination, oppression, vulnerability based on gender, race, ethnicity, sexual orientation, gender identity, disability, class, and when these forms of discrimination intersect, it causes grave extreme marginalization. Intersectional justice focuses on someone's disadvantage being someone else's privilege. With this now, I request Professor Dr. Sanjay Jain to show light on the topic.
Good afternoon, everybody. I hope there is some energy in the hall. And I feel privileged to be in between the two giants, Justice Anand, after my speech, and before my speech already you have heard absolutely intellectually stimulating reflections of Justice Bhatkar. So, Honorable Justice Bhatkar, other judges of the Madras High Court, distinguished invitees, students, and particularly I would like to identify, along with Justice Bhatkar, Justice Anand, who also happened to cite me in one of his judgments. I don't know, Madras High Court has a special affection for me, it seems. I would also like to identify and acknowledge my student, Sharat Chandran, and in absentia, I would like to thank Justice Lakshminath, Lakshmi Narayan, sorry, I miss his name, Justice Lakshmi Narayan, and I would like to thank Mr. Raghavan for having me here. It has been absolute treat to hear various speeches, and I must say that I have attended so many conferences. Attending conferences is a part of life of professors, and most of the conferences find it difficult to maintain the same level. I think Mr. Raghavan and his team has been able to achieve that very difficult task. So kudos to them. And particularly to, I think, my young lawyers who commenced the discussion on the right pitch, and I think who also summarized the discussion on right pitch. And I'm quite sure that same is going to happen with me as well, with my student Sharan going to summarize the session. Now, what I want to do, the bad news is that I had prepared some notes, and I thought that I had kept those notes in home, and when in the morning I was trying to put them in my bag, I realized that I messed up. I kept them somewhere else, so I'm without notes. But sometimes it is better to be with points without maybe PowerPoints or so on and so forth. So let me directly speak to my mind. What I want to do is to first briefly look at the idea of intersectionality in general, and then try and locate it in Constitution of India. But before I do both these things, let me very briefly allude to a very interesting altercation which I had recently with a very renowned activist, Dr. Sanjay Jain, when he was in National Law School. He delivered a very sparkling speech and talked a lot about how there is a caste consciousness in India and how caste discrimination writ large, this and that. And then during the question and answer, I raised a point, and I tried to join issue with him by asking him, when you talk about caste discrimination, what about intersection of caste with other markers of diversity? Are you oblivious to these markers? When you talk about caste discrimination, are you prioritizing caste discrimination over other discriminations, other markers of discrimination? What about, I asked him, what about discrimination based on disability, for example, discrimination based on physical and mental disability? Unlike caste discrimination, which has occupied our mindsets for last 50, 60 years, in fact 75 years after the Constitution has come into force, and maybe around 30, 40 years prior to the commencement of the Constitution. On the other hand, when you look at physical and mental disability, our engagement has been negative with this concept, right? We have always looked at the idea of physical and mental disability in terms of disease, in terms of an issue requiring rehabilitation, right? If somebody is in state of physical and mental disability, needs to be rehabilitated, she needs to be rehabilitated, or she needs to be treated. So I asked, what about addressing this marker of disability or discrimination, for example? Are we trying to create a hierarchy when we talk about discrimination, I asked. And then, very honestly, I must say this before this audience, he very sincerely told me that I agree that there is a gap in my epistemological approach to the discrimination, and I want to fill that gap. And let's engage on the issue of how we can strengthen the discrimination law with invocation of idea of intersectionality. And then came this very interesting article which I wrote on his invitation as a commission editor to Indian Express, and we want to take this idea of looking at the notion of anti-discrimination from the perspective of intersectionality. Now, what is intersectionality? Shreya Atre, one of the noted scholars from India, a very bright student from Nalsar and now a well-known scholar, and I think happened to be the classmate of Sharan, so there seems to be a Shreya has identified 5 strands of intersectionality. What happens? In 5 ways at least, intersectionality can make a difference or can make a headway in law of anti-discrimination. Firstly, she argues that intersectionality helps us to go beyond the binary of sameness and difference. Because as constitutional lawyers or as students of constitutional law, particularly in India, we have this habit of looking at Articles 15 and 16 and the grounds of non-discrimination mentioned in these articles as single axis grounds. So discrimination on the ground of caste, discrimination on the ground of sex, etc., etc. And mostly we invoke doctrine of reasonable classification or manifest arbitrariness or of late proportionality. But there are judgments where judges have invoked all the 3 doctrines also in one single judgment, making it very difficult to understand whether we have any complex hierarchy of judicial review in India like US, because the latest very interesting judgment of Supreme Court, Ramesh Chandra Singh versus Union of India 2023, where the classification is hit according to the judges, not only on the ground of reasonable classification, on the ground of manifest arbitrariness, but also on the count that it is in violation of principle of proportionality. So our journey of the constitutional journey of anti-discrimination law is very turbulent, and that's where sameness and difference, we either we talk in terms of differential treatment or we talk in terms of similar treatment. But are we trying to go beyond sameness and difference? I think there intersectionality, and I will come back to it. The next important strand of intersectionality, according to Shreya Atre, is pattern of group disadvantage. Each group, particularly when you belong to different disadvantageous identities, particularly when you are required to perform different disadvantageous identities, like when you are disabled, when you are a person belonging to LGBTQ, when you are Dalit, so you are simultaneously performing a number of identities and you represent a number of disadvantaged groups simultaneously. So how such a location of yours, how it affects you, what are your experiences, and can such experiences be captured by the conventional interpretation of Articles 15 and 16? The third aspect which Shreya Atre talks about, she argues that when we use intersectionality, we move towards integrity. We integrate the disadvantages. We don't look at disadvantages in a fragmented manner. We try and find out, invoking intersectionality, how different disadvantages result in a very multi-layered and complex operation. So therefore, integrity. The fourth point she talks about is, she says that by invoking intersectionality, you can contextualize anti-discrimination. So, for example, a Muslim woman or a Muslim person with disability, there is a context of both minority as well as disability in case of such a citizen, right? So therefore, she talks about the context. And finally, she also talks about transformation, how intersectionality has the potential to transform the entire notion of anti-discrimination law, right? It is beyond the scope of this talk to take these points any further. But I think she provides a very good beginning to convey the message that how through the cracks of the formal equality, disadvantages falls apart, disadvantages somehow failed to capture the notice of law. Now, Kimberly Crenshaw, a famous feminist, she wrote an article in 1989 and earned reputation for coining this very idea of intersectionality. And very metaphorically, she explains what does she mean by intersectionality. She says that when there is an accident on an intersection, right, with several cars hitting a particular person, can you say with certainty that exactly by which car and what kind of injury is caused? So it's an accident which has happened on intersection, and a number of cars are culprits, and we find it difficult to attribute with accuracy to any particular car the accident. So that's what she argues. She focuses on black women and argues that the disadvantage faced by black women, the multiple identity of a black woman, her operation as a black person and her operation as a woman, when both these operations interact, when both these operations combine, a very complex operation is produced which cannot be captured by the conventional jurisprudence of 14th Amendment. That's what she argues. So now let me find out what is the position in India. Because I think it is undeniable that single axis discrimination cannot capture the multi-layered operation, and it has been now very well recognized. This point has been very well recognized. In fact, Equality Act of UK has a provision which has to an extent legislated the idea of intersectionality, but unfortunately till this date, that section, I think if I remember correctly, section 14 of Equality Act, it remains unenforced, but by using this section you can invoke discrimination on at least two grounds. Sorry, on maximum two grounds. Right. Now, before I go to constitution, let me clarify what is happening to tackle with single axis discrimination in major jurisdictions, because we have now recognized that single axis jurisdiction, the idea that you can capture the discrimination by using formal equality is not a valid idea no longer. So how can we go forward? So for example, in jurisdictions like Canada and USA, they have evolved the doctrine of disparate impact, or doctrine of disparate impact and undue the burdensome impact. How disproportionate impact of a law can result in discrimination. So a facially neutral law may have a disparate impact, may cause disadvantage which needs to be surgically tackled. You can't just tackle such a disadvantage from the notion with invocation of notion of formal equality. Apart from that, even when single axis discrimination is used, that is to say discrimination on one ground only is focused, there are at least following nuances to single axis approach. So first is, okay, single axis approach, but interpret the axis of discrimination capaciously. So capacious single axis approach, you find this approach in South Africa. You also to an extent find this approach, I think, in Canada as well. But South Africa I'm quite sure. Now what does I mean by capacious single axis approach. So suppose I am dealing with sex discrimination. I would interpret sex discrimination so broadly, so capaciously, to include the allied aspects of the identity of the subject. So suppose you are dealing with a disabled Dalit women, like Justice Chandrachud happened to deal in Wali's case. So she was Dalit, she was women, and she was disabled. So Indian Constitution only talks about sex discrimination. Indian Constitution does not talk about disability discrimination. And in terms of combination of disability and caste also, Indian Constitution is silent. But what Justice Chandrachud did, he tried to look at the complex operation of these women resulted from the intersection of caste, gender and disability. So capacious. So although he was tackling sex discrimination, he read into the sex discrimination the operation resulted from disability, resulting from physical and mental disability and caste. Then there is another strand which is known as substantially similar ground, substantially single axis approach. So okay, there may be other reasons of discrimination, but you try to interpret the single axis in such a manner as to somehow tackle the allied reasons. This is different from capacious. This is slightly narrower than capacious approach. Then in certain jurisdictions we also talk about multiple jurisdiction discrimination and additive discrimination. But again, multiple discrimination is just like you have single axis discrimination, you have discrimination resulting from two grounds, but the court's looking at each ground as a distinct ground of discrimination, right? So this is the terminology. So how complex the anti-discrimination law has become around the world is clear from this rather sketchy analysis. Now let me go to the Indian Constitution. I know time is less, so I don't want to take much of your time. But nevertheless, if you look at the Indian Constitution and particularly Article 15, generally we don't look at the four very important words at the end of Article 15 and 16. 16.2 and 15.1 and 2. There are four very important words which we don't pay much attention, and judiciary has not taken cognizance of these words. So what are those four words? Or any of them? So what exactly is meant by or any of them? Whether Indian Constitution is conveying the idea that we adopt a single axis anti-discrimination law, or whether Indian Constitution is conveying the idea that discrimination can be complex and can be on multiple grounds. In my opinion, the latter approach is the correct approach. Indeed, textually there is enough evidence in the language of Articles 15 and 16 that Indian Constitution does not advocate single axis anti-discrimination. Indian Constitution recognizes multi-layered and complex discrimination. Next question arises, okay, whether Indian Constitution limits the discrimination on certain grounds? Parrot-like answer mostly is yes. However, I can draw somewhat from the analysis of Shreya Atren, partly from my own understanding, and can argue that these are not grounds basically. What you read under Articles 15.1 or 16 15.2 or 16.2, they are not grounds. In my opinion, they are causes of discrimination. So we should not adopt a quantitative approach. Just let's not count, okay, 1, 2, 3, 4, 5, these are the grounds. No. Because the framers of the Constitution, when they incorporated these grounds, they did not incorporate these elements merely as numbers. Probably the rationale behind incorporation of those grounds was that, okay, these are the credible and cognizable causes of discrimination. You know, discrimination on the ground of religion, discrimination on the ground of caste, discrimination on the ground of sex, well known. Question arises whether this list is a inclusive list, exhaustive list. I make out a case and I provoke the audience, and I would invite inputs. I argue that we can interpret Article 15, 1, 2 and 16.2 adjustum generis and argue that or any of them and the list of the grounds, right? So or any of them would mean certain other causes of discrimination, causes which result in discrimination. So I can argue that, okay, when the Constitution was adopted, the causes which were present to the framers, to the minds of the constitutional framers, they were incorporated, but the process is ongoing and the courts can continue to develop, continue to add into these causes. So I make out a case for constitutional common law of anti-discrimination and make a case for addition of grounds, and therefore, for example, physical and mental disability or sexual orientation may be the candidates. Now people may ask, but what about only? How do you respond to word only? I think Sharath is going to talk about it, but let me argue that grounds only of, the language is grounds only of. So I would like to interpret the phrase grounds only of to mean, okay, not on the discrimination is not limited to grounds only of blah blah blah, but it may be also on certain other grounds. So can we interpret grounds only of like this? Now you may argue, some particularly the lawyers trained in analytical jurisprudence may argue that this is against semantics. But indeed, I have a very strong support to this view from the views of my Lord Chief Justice D.Y. Chandrachud, because in Nautej, he very categorically held, and indeed he is a lone voice, but nevertheless a formidable voice in my opinion, and since nobody has struck a note of discordance from his point. So it may be possible to argue that the entire court is in resonance with his voice. And he very clearly said that we need to abandon the formalism underlying Article 15 and 16. So we have to use Articles 15 and 16 teleologically. We should focus on purpose underlying Articles 15 and 16 rather than only having focus on language. I would like to argue that H.L.A. Hart has stated that legal system is consisted of rules. He defined law as system of rules, but his student Ronald Dworkin very aptly exposed the gap in his analysis by making out a very strong case for the application of principles. Therefore, I would argue that intersectionality is a principle which must complement the rules like provisions of Articles 15 and 16. And therefore, instead of indulging in whether we should have this interpretation or that interpretation, because interpretation is a dynamic process and there is no rule of thumb that interpretation has to be literal. Therefore, in my opinion, there is a fair amount of scope to make a very solid case for incorporation of intersectionality. Now, before I conclude, this is my textual response, slightly incohesive, but hopefully with your inputs I can make it much more refined. Finally, before concluding, let me say that intersectionality allows you to challenge the structural discrimination. The conventional anti-discrimination law requires both discriminator and discriminatee. You require a discriminator as well as discriminatee. But when there is a structural discrimination, when there is a latent discrimination, there may be discriminatee, but you don't have discriminators. Like as persons with disability, when we are told that we are not eligible to become judges, there is no discriminator, because persons with disability are unfit to be judges. I think is a constitutional norm, superficial constitutional norm, ableist constitutional norm. And if you want to challenge this norm, if you want to challenge the ableism underlying this norm, then you can't use traditional techniques of constitutional jurisprudence. That would take you nowhere. And that's what done by Justice Chandrachud in Vikas Kumar, when he very rightly argued that before you engage in the process of exclusion, find out, explore the possibility whether you can accommodate and whether you can accommodate the people interested in a particular avocation reasonably. So he made a history by recognizing that principle of equality qua disabled cannot be practiced in India any longer without first invoking the idea of reasonable accommodation. And the idea of reasonable accommodation is nothing but implicit invocation of idea of intersectionality, because he realized very clearly that by using the traditional norm of anti-discrimination, we cannot tackle the issue of disability-based discrimination. So friends, let me formally thank Mr. Raghavan and his team for giving me this wonderful opportunity to be amidst you and to allow me to speak to my mind on a topic which is very, very dear to me. And I hope that disability studies would become a part of the mainstream of law with time to come. And I would also make out a case by saying that if you critique fundamental concepts like equality and liberty from the standpoint of disability, then your focus is, you can focus on the topic more precisely, more surgically, and more intrusively, penetratingly. Right? So thank you very much. Thanks.
Thank you, Professor, for your enlightening words. The principle of intersectionality is the need of the hour indeed. Thank you. And may I invite Mr. Sharath Chandran to come over to the dais to offer his reflection and understanding on the topic.
Honorable Justice R. Subramaniam, Justice Madhura Batkar, members of the office bearers and members of the MMBA, dignitaries and ladies and gentlemen. It's a tough topic on a late afternoon, I do agree, I do admit. But two of the themes which Professor Jain has captured in the last 25-30 minutes, I'd just like to sum that up. The first point is relevant because it has a history with our court, and I thought I should just mention this. Because the word, if you look at Article 15, subclause 1, it says the state shall not discriminate only on the ground of, then you have the 5 grounds, or any of them. Now the word only happened to be the preoccupation of the only thing that preoccupied the judges of the earlier days was the word only. and it had them preoccupied for a pretty long time. But interestingly, it is our court, a division bench of Justice Rajamanar and Justice Vishwanath Shastri way back in 1951, who said that it does not make any difference if you just read 15.1 without the word only. So that limitation imposed on 15.1 by reading the word only can be just ignored for the minute, and the article can be read without that. It took Justice A.P. Shah and Justice Muralidhar 60 years, almost 60 years, in 2009 in NAS Foundation to say the same thing. That's number one. Number two, the 5 grounds have now been held to be not exhaustive, which means that you can have sex discrimination, which includes sexual orientation. And that's the view taken by Justice Anand Venkatesh in that Shushma's case, in the LGBT case, which happened. He, of course, followed Navtej Singh Johar and then did that. So that's 15.1 is actually a very, it has a historical significance because 15.1 is taken from the Government of India Act. And so then they took the exact wordings and then put it here. And for over 60 years, we had the difficulty of not understanding what only meant. So only was a limitation that only limited us, and fortunately today we don't have that problem. The second point, which Professor Jain was trying to address, was the issue of indirect discrimination, which means basically you may have a neutral law, a law which operates neutrally, but its effects will operate in a manner that discriminates. The classic example of there was a recent decision of Justice Chandrachud and Colonel Nitisha, which dealt with a case where the law was framed from the standpoint of men in the army. So when you applied a law framed for men in the context of women, the result was that most women were disqualified. But the army filed an affidavit saying, no, look, we have, this is the law, this is the rule. Right or wrong, this is our rule. And therefore, we have applied the rule, and if they are disqualified, they are disqualified. That's all. Justice Chandrachud then refers to a 1973 decision of Supreme Court of US and says, a law which has the effect of, a neutral law which has the effect of discriminating against a large section of people and making them disqualified, suffers from what is known as indirect discrimination. So this is another concept that has come into our jurisprudence. And before I wind up, I also must mention that 3 of our recent decisions, I think I was mentioning this to Professor Jain when he took this topic. It's of interest to note that 3 of our judgments of our court, one of Honorable Justice Sundar in that notary's case, where he held that a person who a notary public is entitled to be given the benefits of the Persons with Disabilities Act, notwithstanding the fact the state said that that's not a post. So he read that in, and that's one decision. The second one, of course, is Justice Swaminathan's judgment in that case which involved a person who was required to go to the registrar's office. He said no. He read the principle of the Persons with Disabilities Act into the executive order. And the third is, of course, Justice Anand Venkatesh's judgment on Article 15. In fact, the last judgment captures all what Professor Jain was attempting to say. So if more elaboration is required, you can definitely look that up. So I just like to conclude by saying that there is this interesting line in Justice Swaminathan's judgment saying that the Indian Constitution is a steel frame, and its frame is malleable enough and must travel enough to reach the last person. So on that count, discrimination of any kind, these are concepts which are coming up. It's going to take some time because we have to change our traditional law, but it's an emerging concept. And I thank Professor Jain for coming here and giving us his thoughts on this new and emerging topic in law. Thank you. Thank you for giving me the opportunity to sum it up.
On behalf of the MMBA, we thank Mr. Sharat Chandran for his observation. Thank you, Mr. and Mrs. Jain, for the great session.